So here we are in Southport, and this is the HSBC building, which used to of course be the Preston Bank, as you can see on the front of the facade. It's a bit noisy here, so I think what we'll do is just pop down the side alley, which is just there, and discuss the case of Milroy and Lord, which, as you know, is about shares in a bank. So let's go and discuss Milroy and Lord. Hello, so here we are outside the HSBC Bank in Southport. Hitherto it was also the Preston Bank. And why is that important? Well, because the case I want to consider today, Milroy and Lord, related to 50 shares. 50 shares in the Bank of Louisiana as subject matter. So this case is very important to us because, as well as dealing with intangible property, so shares in a bank, it's a case from which we get the phrase from Lord Justice Turner, quote, "There is no equity in this court to perfect an imperfect gift," close quote. So that might give you a hint about what's coming in terms of constitution of trust, the idea of properly ensuring that formalities are carried out to ensure property passes correctly so that a valid trust is formed. Well, here are the facts. Basically, you have two nieces. Niece number one is a beneficiary under a trust, and niece number two is a beneficiary pursuant to a will. So if this trust can be invalidated, the asset value in the trust will go into the estate and therefore will be capable of distribution pursuant to the will, and therefore that niece will benefit. So this niece is arguing that the trust for this niece in the 50 shares in the Bank of Louisiana is invalid, that she should lose out. Why did this come about? Well, a chap called Thomas Medley transferred 50 shares in the Bank of Louisiana to Samuel Lord. And Samuel Lord was the individual who was given the shares but did nothing with them. So didn't, as I've said, pursuant to the constitution of the Bank of Louisiana, register the transfer properly. Ergo, it was the case that the title had not been properly transferred. Thomas Medley had done all that he could do, but unfortunately Samuel Lord, even though he also had a power of attorney over the estate of Thomas Medley, Samuel Lord didn't do enough. And therefore that's why we get this phrase from Lord Justice Turner, "There's no equity in this court to perfect an imperfect gift." The transmission of property was imperfect, hadn't been fully constituted by Samuel Lord. Meaning then, therefore, at first instance, when Vice-Chancellor Stewart hears this case, who does say that the trust is valid, we see that the court is trying to perfect an imperfect gift. When it gets appealed up to the Court of Appeal, this niece wins. That's to say, the will beneficiary niece and the trust beneficiary niece loses, because the court says, the Court of Appeal, that there is no equity in this court to perfect an imperfect gift. So what the court are trying to do in knocking out this badly constituted trust is to ensure that donors, or intending testators, people trying to pass property, do it properly. Use the proper formalities and systems to ensure that property is passed. So, next time you're up in Southport, do come and have a look at this. HSBC, hitherto the Preston Bank. Perhaps also check out Broadhurst Books, which is a very good bookshop up here. And have a stroll generally around Southport. And whilst you do, have a think about Milroy and Lord, this 1862 authority that starts off our discussion of intangible subject matter and the formalities that are required to, past that species of subject matter.
Next, of course, in our story comes Rose, 1952, and then, of course, up to Pennington and Wayne, and Lady Justice Arden's tempering the wind against the shorn lamb as part of our discussions on the constitution of trusts. So from here, outside HSBC in Southport, I'll say goodbye. So goodbye.